morning, everybody. A very warm welcome to one and all. So that's our lovely panel for the topic White Collar Crime 2026, the New Age of Enforcement, PMLA, SFIO, and Digital Fraud Investigation. So this topic is very new to me, not because it's white collar. We've been discussing about white collar since years now. But today we are going to talk about the new age of enforcement, which includes digital fraud investigation as well, which is very new. And since we are living in time where economic offenses have transformed dramatically, transactions are no longer limited to bank accounts, but they move through mobile wallets, cryptocurrencies, NFTs, and digital ledgers. Corporate fraud today is not only about account books. It can be coded into cloud systems, hidden in algorithms, and spread across layer subsidiaries and shell entities. Cybercrime is industrialized with technology. Fraudsters are moving faster than the investigative agencies. In response, India has witnessed a wide range of PMLA intervention. SFIO has emerged as one of the most powerful corporate investigative body. And cyber cells, ladies and gentlemen, has played a vital role in catching the fraudsters who are spying away and hiding amongst the coded networks. The central question that we will discuss today as we talk about the new age of enforcement will be, can investigations evolve as fast as the criminals? Or can law evolve as fast as technology? On that note, let us begin the conversation with our first speaker, and that will be Senior Advocate Mr. Pramod Dubey. So my question to you is, do you believe that the reverse burden of proof under PMLA remain justified in today's new high-tech enforcement heavy environment? Or should the parliament re-examine the safeguards, considering because all the substantive offences on which PMLA stands are primarily under trial. They are not decided as yet. So over to you.
Thank you, Vaibhavi, and thank you, BW Legal. And my sincere respect to Mr. Basin, the Bhishma Pitama of the legal fraternity is here, Mr. Dr. Batra. This reverse burden in the PMLA is basically exception to the general law. So they incorporated section 24 of the PMLA. And you'll find this reverse burden is not only PMLA, almost in all special statute, all special act, there is a presumption and then reverse burden. And it is always debatable whether the reverse burden would be adjudicated at the time of the remand, time of the bail, time of the charge, during the trial. So different judgments on this aspect, but ultimately this issue was decided in Vijay Madan Lal Chaudhary by the Supreme Court, that celebrated judgment as on date it is in existence, though there is a review is pending and the arguments yet to start in the review. But be that maybe, today the reverse burden section 24, one thing we must understand is the reverse burden will come into force only if the foundational fact would be established by the prosecuting agency. So the first onus, the burden lies on the prosecuting agency to prove the case prima facie, so that the burden will shift to the accused or the defense to discharge the burden. On that aspect, the Supreme Court has gone far away. Latest judgment the Supreme Court has passed that even at the time of the bail, once the twin condition is there and the reverse burden is on the accused, so the prosecuting agency, even in the PMLA case, will supply all the documents which have been seized. Though there is a law that the document which is relied upon will and filed by the prosecuting agency would be supplied to the accused. So the reverse burden is not a small thing. It has basically enhanced the scope of the adjudication. That's why the court passed the order, you supply all the documents and then the accused would be better position. Even you have just mentioned the SFIO. So there also you will find the twin condition, the stringent condition. You have mentioned the digital crime, and this is of the technology and the fraud. Today, if you see the Today Times of India, there is a very interesting article which is pertaining to Bijnor. What the new way of the commission of the offense is, they are sending the e-invitation, like the marriage invitation, other things, and the moment you will open the invitation, the money will be transferred from your account. So this is also the precaution. Today Times of India. No, don't open the invitation. Suppose, baby, you are sending me,
Absolutely.
and I opening my WhatsApp message, the money would transfer.
Already
So
gone.
this is
Yes.
very difficult phase we are going through, and in India still we are lacking. We are lacking. We don't have the infrastructure. Our investigating agency, enforcement agency are not well equipped. The government must spare some fund, resources, the proper training. The officers are not duly trained. Every day we are coming across this kind of the, and forget this your white color, blue color. Now the digital offenses, technology offenses, cyber offenses, this, the entire global is now suffering this. So this is very important. And again, I'm coming back to your uh, reverse burden on section 24. Not only 24, there is also section 23. 23 also the PMLA Act, there is also reverse burden. So reverse burden is not a small thing, but there is one judgment of our own High Court, Justice Bambani, and Mr. Sood must be knowing this judgment. Justice Bambani has written beautifully the what is the impact of the reverse burden, how it is going to impact the right of the accused, and he has tried to balance the reverse burden with Article 21. So you cannot ignore Article 21. So the genesis of the entire test would be Article 21, the personal liberty and the jewel of the Constitution would be paramount consideration. But yes, the reverse burden is a very difficult task for the defense and for the accused side. It's very easy for the prosecution to argue before the court, that sir, there is a matter and there is a presumption. Despite we are coming across every day in the PMLA matter, SFIO matter, every day the first argument that this is the reverse burden, they have to satisfy. Despite the law is settled, they are not aware, but the judges are also prejudiced, and we are suffering a lot. So it is giving the lot of trouble these days.
Absolutely, sir. Having said that, I remembered one of my matters in which I was cross-examining a CFSL expert from the chemistry division. And when we cross-examined that expert, we realized that the machines and the equipments they are using for the current year 2023's examination, forensic examination, that machinery belonged to the year 2021. So, rather 2001, rather. So, that is how we realize that in 2023, the machines that our forensic bodies are having, they are of the year 2001, 2002. So, that is the current situation of our investigative bodies, and we need to really move ahead of time. And because with AI and the enforcement and digital frauds happening with this energy, we need to really buck up.
For lighter side, Vaibhavi, I will take your permission because you are the uncle, you are old. I'm very happy to hear from your mouth that you are cross-examining, because it's a second generation. And one thing I would like to mention, Vaibhavi's father, Mr. Sharma, is one of the best examiner in Delhi. So I'm very happy because this art is distinguished every day. No one is coming forward. The young generation are least interested in conducting the trial. They are mostly interested in doing the appellate work. But unless and until you have the experience in the trial court, you can't become a good lawyer in the criminal side. Mr. Basin is here, and my senior, Mr. Siddharth Luthra, he started his career with Mr. Basin's chamber, and he was assigned to the trial court work, civil work, and the criminal work. That's why he's here. So I must appreciate your effort. You are doing the cross-examination.
I enjoy cross-examining the most. Thank you. I enjoy cross-examining the most, and that is the high point of my day when I have to cross-examine a witness. And Later in the office, I prepare for it. So that's wonderful. Thank you, sir. So having said that, so enforcement is one side of the story, and being defense counsel, flip side being the rights of the citizens. So having said that, my next question will be to Advocate, Senior Advocate Mr. Vivek Sood. Sir, in your opinion, do you think is the current statutory framework doing enough to balance ED's need for quick attachment versus the rights of the citizens, the accuser's right to operate its businesses? And also, sir, if not, what changes do you think the coming year deserves?
First of all, I'm grateful to this forum to bring me here. I think this is the second time I'm here. It's a very interesting question you asked. Let me just give a backdrop of how the statutory framework of attachment under PMLA functions. First of all, when a search and seizure is to be conducted, it has to be based upon information having connectivity with reasons to believe. So there has to be a reason to believe before a search and seizure operation is conducted.
Absolutely.
Then we come to provisional attachment. There again, you must have reasons to believe that PMLA, the crimes, the proceeds of crimes are there, or money laundering crime has been committed. Then we have the provision for show cause notice. Again, reasons to believe have to exist before a show cause notice is given. Then the matter goes into adjudication. And adjudication has to be done by an authority. It's a quasi-judicial authority. It's not an administrative act. Again, there has to be judicial application of mind before the provisional attachment is converted into an attachment, or the freezing, retention of assets have to take place. An order has to be passed in writing, showing application of mind. Now, with all these checks and balances at every stage of the PMLA proceedings, from search and seizure to provisional attachment to retention of records to attachment, show cause notice, there are so many checks and balances which protect the rights of the accused and also balance the same with the right of the investigating agency to find the truth. Therefore, in my view, the statutory framework is in place. And apart from the statutory framework, we have an independent judiciary, and you have a gamut of case law that has expanded the meaning of reasons to believe, application of mind. It cannot be perfunctory. Reasons to believe must be based on relevant factors. There has to be judicial application of mind, cannot be arbitrary. Reasons must be justifiable. There has to be evidence in support of the reasons to believe. That evidence and material has to be tangible and credible. So we have enough checks and balances to protect the rights of the accused under the PMLA regime, that is the PMLA Act, read with the case law. However, the ground realities are very different. Now that's where the problem is, and I will urge the government to conduct some kind of an audit on how the PMLA regime is being implemented at the ground level. All these principles of reason to believe, etc., are only being applied in letter, not in spirit. We have seen Mr. Dubey and I, we appear in some matters, for different accused, and we see it every day that at every level, the principles of law, the principles of justice are not being applied. It is very perfunctory. It is very one-sided. The adjudication mechanism needs reforms. Some accountability has to be enforced. There has to be some audit of what's happening, because all these stages are being very mechanically applied. In fact, one also observes that even at the appellate stage, when you go and file an appeal before the appellate tribunal, there also you find a carry forward of these principles being applied in letter and not in spirit. So while the statutory framework is robust, the implementation at ground zero needs imperative reforms, so therefore that is my expectation in 2026. Now the last point I want to make is that we have seen that where the ED is investigating proceeds of crime, very frequently they allege as if the entire business is a proceeds of crime. So they are not able to discern and distinguish between what is legitimate and what is proceeds of crime. Now that hurts the economy, that hurts the corporate world, that hurts bona fide buyers of property, bona fide operators, business operators. So therefore I will urge the government to take stock of the ground realities and improvise this implementation at the ground level.
So thank you, sir, for laying out a detailed analogy for a foolproof.
Important, Vaibhavi.
Please, please, sir.
Just he has elaborated reason to believe. The first stage, reason to believe. Second, adjudication. If there is 100 matters before the adjudicating authority, out of 100, you won't find in single order passed by adjudicating authority where the reason to believe has been dealt with. And 99, even 100 attachment is confirmed with one paragraph. What order is coming these days? Their case, the reply, rejoinder, one paragraph, last order confirmed. There is no application of mind, and the situation we are going through, it's a very miserable situation. We are arguing everything not dealt with. So cause notice being issued by adjudicating authority, no reason to believe. Same copy paste, order is passed, 100% confirmation of the attachment. 100%.
So when we file appeals to the appellate tribunal PMLA, our main ground of that appeal is that the order by the adjudicating authority is not a reasoned order. They've just stated the facts of the case, the reasoning by the prosecution, the defense by the defense counsels, but the order lacks what reasons have the adjudicating authority applied and how they've applied their mind and how they've come to the conclusion that yes, these are proceeds of crime and we need to go ahead with the ECIR. So, very well highlighted, sir. And with that, we had Mr. Sood just touched upon the corporates and how the corporates need to function in the year 2026. So, having said that, I'll move to the next speaker, Advocate Devesh Tripathi. So, what do you think are the common mistakes corporates are making while dealing with enforcement actions, the organized crimes, and the frauds, and how can they avoid them and deal with them? Over to you.
Thank you for inviting me here. So first of all, I would like to take a leverage that there should be reasons to believe on accused also. That is completely missing. So I would like to start my submission here. Whatsoever we submit in our reply, in our submissions, quasi-judicial authority is completely non-judicial kind of authority. So it is a kind of defunct state of mind that you are not discharging your duty well. So what kind of judicial authority? Suppose it is quasi or judicial whatsoever, you are not performing your own duty. So what kind of things we have to opt? My reply, first of all, legal awareness.
Right.
The problem with our corporate system, and one of key speaker told very well
Right.
in previous session, that for law there is always less budget. Okay,
Absolutely.
so we are facing this kind of things everywhere. I am representing to government side also since 2017. You know how government pays to councils, and not like that, but corporates are also having very less interest to pay to advocates. It is all again a kind of different debate.
That's a very different challenge that we
Yeah,
are facing,
yeah.
and that's maybe the part of another
So this is
session.
the car. This is something legal awareness. Whatsoever in-house counsel, even in India, it is very unfortunate, and I am not hurting anybody's sentiment, any professional. Like we are having anything, any problem, still we have some convention that do not go to consult doctor, go to chemist shop, medical store. So something like that, consult your CA. CA is something, it's okay. I am not challenging and I am not debating on this. But something like expert domain should be there. Suppose you are having PMLA case or FEMA case, you should go there. At least in metros, you can avail that kind of services.
To an expert lawyer
To
who's
an
dealing
expert
with,
lawyer,
absolutely,
domain
absolutely.
expert. That is number one. Number two, we always see some kind of nuisance on behalf of our clients, big corporates, that they have called me, they have given me notice, someone, since it was FEMA. So we did not take it very seriously because FEMA is civil law. It is not Faraday's. So we went there, but all of a sudden it was converted to PMLA. So after doing some more kind of creating mess, you are coming to us, and then we have to do something to cure that situation. So law enforcement agency, our seniors told very well how they are doing at all. But for this side also, there is some connect the dot which has to be cured, because if our threat is so big, if there are so much challenges, then our preparations also to be accordingly in the reciprocation of that kind of big challenges.
Absolutely.
So one is awareness, second is expert domain to be consulted, and third, whatsoever digital records you are having, you have to scrutinize those things. Unnecessarily involving your mobile phones, your data, your email ID, because what is the first challenge? If there is any search rate, anything, they always try to snatch your phone. They are
Absolutely.
not, they are
Absolutely.
not concerned with you, because phone is the key. So many things to be evolved by the corporate side also, how to meet these challenges. So this is my point.
Absolutely. Thank you, Mr. Tripathi, for contextualizing it. And the corporates should really, I think he's pointed out some very great points, that instead of waiting for the matter to slip out of hands, at first, in the first instance, just go to an expert. That's there. So, having discussed that, nowadays we are also facing a lot of digital and cyber enabled frauds, where criminals operate digitally. As Mr. Tripathi has correctly pointed out, mobile phones are the key, and technology itself has become both the weapon and the battlefield. The crimes are happening digitally, and the data is also present digitally. So, moving on to our next speaker, Ms. Sana Raees Khan. My question to you, Sana, is, in your opinion, what are the most dangerous digital frauds and techniques emerging in the year 2026? Is it the deepfake KYC or real time payment frauds?
So each one, the unsettling truth is that each one is a different face of the same monster. Let me deal with the deepfake KYC first, which is AI impersonation. Since I have seen its impact not just in the financial sector, but also in the world of personality rights, while we were dealing with case of Mr. Kumar Sanu, what was the most shocking aspect was not just unauthorized monetization of his identity, but also manufacturing of his likeness, like his voice, his expression, his emotions were cloned to sell brands which he never endorsed. Though we secure protection of his personality rights, the struggle still continues because we've just recently filed for a similar suit for protection of personality rights for Shilpa Shetty, and we are just in the process of filing for Raveena Tandon. What we have discovered is deepfake and obscene videos and pictures created to look real, to feel real, to sound real, somewhere. And the objective does not necessarily need to be monetary. The objective could be harassment, defamation, because public image, unlike financial transactions, cannot be reversed. Then coming to synthetic identities, what you just mentioned, that's like totally fake identities created through stolen data or fabricated information. These identities can now create accounts, can pass verification check without a real person even behind them. Then coming to payment fraud, of course, that's the most damaging one, because through a manipulated link or through a clone voice call, the entire money gets transferred, and then there is no reversal. So of course now AI affects everyone. It's not just a big city problem. It affects students applying for jobs, or it even affects a basic shopkeeper having a QR code. Even recently, teachers, a teacher's voice was cloned to demand fees from the parents of the students, and that's how normalized it has become. So, and now, even emotional manipulation is also automated. Like,
Not to forget digital arrest. That is
exactly,
one of these.
exactly, digital arrest. Even emotional manipulation is also now automated. Words like, Papa, please send it urgently, I need it urgently. All these words are used, so it looks very real, it feels like family, not like a scam. So, and of course, now AI is scalable. One voice can be used to make 1,000 calls. One face can be used to create, multiple videos, and just one fake identity to open dozens of accounts. So, what is needed now is, of course, investigative and judicial framework that has to evolve more rapidly. Because now, what is the need of the hour is that digital identity in India's digital revolution, digital identity should be as protectable as our financial assets. Victims of AI fraud should be given faster legal remedies, should be, that there has to be a faster takedown mechanism across social media platforms. There has to be specialized cybercrime courts, and there has to be a digital literacy, not just at grassroots level, but also, at in even metro, not just in metro cities, at grassroots levels. Because now identity just cannot be accepted like that. It has to be verified. Today, in an AI era, the real battle is not between human and machines. It is between truth and manufactured reality. Because, just like how identity can be faked in seconds, even the protection should be delivered in seconds, because law cannot lag behind technology. As I believe that in tomorrow's world, identity is going to be the new currency.
Absolutely.
Thank you.
Thank you, Sana, for illustrating just how sophisticated and global scalable digital fraud has become, and how enforcement has to race against the time with AI-driven techniques and to enable the threats and combat them. So I'll go back to my panelists one by one if they have any one line to sum up today's session, and we can start with Mr. Sood.
In one line, I would say that we need to improvise the implementation processes of the PMLA regime. And secondly, accountability. We still have law enforcement agencies who are following a very colonial approach. So I think there has to be accountability fastened on the law enforcement agencies. This is my take in one line.
Sana, what about you?
So our future is definitely not free from risk. So I believe that law, enforcement, technology, and awareness should definitely be one step ahead of those who misuse AI.
The root cause in our country is, Jasana has just pointed out some problems and regarding the AI other things. In India, the problem is we don't see the future. We don't have the anticipation. We don't have the vision. We start working the moment the problem is there, crisis is there.
Right.
If you see the very popular series that's Last Survivors, Netflix, you will find the entire investigation is based on the technology.
Yes.
Much prior in time, US has started. Now we are following their path in 2025, 2026. Now we are talking about this kind of the problem. You would have imagined then and there, and you had the mechanism to come out from all everything. You have not done anything. Now the problem has started. We all have started suffering. Then is a hue and cry everywhere, everywhere. So the government should go ahead to visualize the problem. This is not only the technology problem. Even you see in Delhi, the traffic problem. We don't have the vision ki how the traffic is going to be there in Delhi after 5 years, 10 years. What is the remedy? You'll find first there is a construction, then demolition, then construction, then demolition. So this kind of the problems, you don't have the solution unless and until you have the predetermined mechanism and the policy.
Absolutely. Devesh, what are your parting thoughts?
Since it is an opportunity to give a concluding statement, so I will not take much time.
Please.
I would like to say that reasons to believe may be written somewhere in any PMLA anywhere, but people should be having reasons to believe in the reputation of our judiciary and these enforcement agency, then only the purpose will be resolved. Until unless our public is not having reasons to believe in the honest functioning of our systems, it is all the defeat of all the purposes and letter and spirit. So we should develop, evolve something that people should have the reasons to believe. Thank you very much.
Conclude the session by saying that enforcement, when we talk about the new era of enforcement, white collar enforcement belongs to some changed laws which are more enabling for the citizens to find the correct protection that they are today wanting, and also to the best intelligence. Because the intelligence is something which will protect us from the upcoming threats that the country is going to face. So with that note, on behalf of the forum, I would like to extend thanks to all the panelists for their insights and valuable feedback, to the organizers for the opportunity, and to the audience for their keen interest and involvement. Thank you.